Welcome to SCOTUStalk. I'm Amy Howe. Thanks for joining us. I'm going to start with a brief recap of what has been happening at the Supreme Court in the past few days. The major development of the week is today's announcement that the Supreme Court will weigh in on whether federal employment discrimination laws protect LGBT employees. The justices had considered a trio of petitions for review at 11 consecutive conferences before finally granting them today. The cases will be argued next fall, with a decision likely early next year. Another high-profile issue that could be before the justices next fall is abortion. A federal appeals court upheld a Louisiana law that requires abortion providers to have the right to admit patients at a nearby hospital. In February, the Supreme Court blocked the state from enforcing that law until the abortion providers could file their appeal. The providers filed that appeal on Wednesday. The justices are likely to rule on the providers' petition before the court's summer recess. Tomorrow, the Supreme Court will hear oral argument in one of the biggest cases of this term. It's a challenge to the decision by Secretary of Commerce Wilbur Ross to add a question about citizenship to the 2020 census. We'll be back next week to break down that oral argument. Now we're going to turn to last week's oral argument in a trademark case with some colorful language. Joining me now is Mark Walsh. Mark is a frequent SCOTUS blog contributor and also writes for the ABA Journal and Education Week. Mark, welcome.
Thanks, Amy. I'm happy to be here.
We're going to take a look back at last week's oral argument in Iancu versus Brunetti, in which the court is considering whether or not the federal government can refuse to register an immoral or scandalous trademark. So tell us a little bit about the trademark in this case and how this case got to the court. It's an interesting trademark, to say the least.
So do you want me to say what the trademark is?
Go ahead. Somebody's got to do it, so it might as well be you.
So I'm going to follow the example of our friend Nina Totenberg, who said in her report, the trademark in this case is a line of clothing, and we'll just give you the letters. It's F-U-C-T. And as Nina said, you can say it out loud and figure out why there's a hubbub over it, because this was a line started by Eric Brunetti, who's an artist in Southern California. In 1990, helped start what's called streetwear, clothing that skateboarders and surfers kind of enjoy, and it was really very popular in the 90s. I can remember seeing it. In my salad days, I used to go to music festivals, and I didn't wear this line of clothing, but I remember seeing it, and I don't think it's quite as popular today. Now Mr. Brunetti has said, he does put new products up on his website, which is sort of the same letters plus .com, and his concern as to why, after many years, I think only about 8 or 9 years ago, he began to seek federal registration, was that he saw a lot of knockoffs, and there was something called the Madrid Agreement, which involved international protections for products and so forth. So he's been seeking federal registration for quite a few years now. So he sought protection from the Patent and Trademark Office. Was rejected under this disparagement clause, and further rejected by there's some sort of a trademark appeals board. And one of his concerns was that the standards that the PTO applies, he views as just viewpoint discrimination. The PTO looks to popular usage and look to the Urban Dictionary, as they did in his case, and of course they just view this as a profane word, and they rejected it. They get many other applications with terms like this, and we'll get into that a little later, I think. But so he challenged that under the First Amendment,
and he went to the U.S. Court of Appeals for the Federal Circuit, and he won.
That's right. The court had reconsidered his case after the Supreme Court's decision in Mattel versus Tam, which involved the disparagement clause of the Lanham Act, and the Supreme Court, in that case, it was 8-0, agreed, at least on the point that the disparagement clause represented viewpoint discrimination and was facially invalid. The 8-member court didn't agree on a whole lot else with regard to that case, which of course involved the rock band called the Slants, who were trying to reclaim that name from the point of view that it was disparaging Asian Americans.
So then the federal government went to the Supreme Court, and the federal government has a really good track record when a federal statute has been declared unconstitutional and asked the justices to weigh in. So the Supreme Court said it was going to take up the case, and so here we were last week. The justices had also dealt with cases involving the F word before. There's a 1971 case called Cohen versus California. That's kind of interesting.
Yes, so a couple of points. The Supreme Court is a state institution. They don't necessarily want to be throwing these words around in oral argument. And just to give a little bit of history and context to this case, in the Cohen case, that involved a man who wore a jacket in a public courthouse that said "F the draft," and of course, you know what it really said. And he faced a criminal sanction, and so his case came up before the Berger Court in 1970 or 71. The decision was 71. And Chief Justice Warren Burger made clear at the beginning by saying, we know what the facts of this case are. You don't need to go into them. But Mr. Cohen's lawyer, a man by the name of Melville Nimmer, thought it was important to get that word out, and he was going to do that, and he did do that. And the Cohen case was mentioned a few times in the arguments last week in Brunetti, and there was a brief in the case from the Cato Institute that refers to a really fascinating law review article by a former law clerk to Justice John Marshall Harlan, who ended up writing the decision in Cohen, which held that this Mr. Cohen's jacket was protected free speech. And Thomas Crettenmaker is the law clerk, and he just tells a few tales in this law review article about how Justice Harlan had asked him to write the opinion, and he said, make it Elizabethan. And the law clerk did not know really what that meant. And it's, even many years later, when he wrote this law review piece, he said, I don't know what that meant, because did he mean like Shakespearean? But Shakespeare used a lot of body language in his plays, and he thinks the justice kind of wanted him to keep it flowery and keep it nice, and that is mostly what it did. But Justice Harlan did use the phrase in the opinion. We don't know. And I tried to check on the OIA website, and there's no recording from the opinion announcement from that era. But this law clerk does relate that Chief Justice Burger even asked Justice Harlan not to use the phrase in the opinion announcement from the bench. And I presume that probably didn't happen. And so that's one background case. And I'll just mention, one other quickly that also came up last week, the FCC versus Pacifica Foundation, which involved the comedian George Carlin and his filthy words monologue, also known as the 7 dirty words you can't say on the airwaves or on television. And if you have never seen that, I'm sure it's available on the internet, but it's also reprinted as an appendix in the Pacifica case. And in that case, the court did uphold the ability of the FCC to regulate over the public airwaves material like that. But that's just some of the backdrop for how those kinds of words are treated by the court, are treated in the courtroom. And the court's gotten more just careful. I'm not sure careful is the right word, but recently, was dealing with some of these words in a case called Fox, FCC versus Fox television stations, and the F words are kind of just used a lot of asterisks in those decisions, and they don't spell them out in 2012.
Yeah, so the lawyer for Eric Brunetti, John Sommer, actually promised in his brief, even before the oral argument, that he wouldn't need to use vulgar terms at the oral argument. And so one of the fun parts about the oral argument was listening to the various verbal gymnastics that the different justices and lawyers used to avoid using the F word out loud. We're going to catalog a couple of those before we dive into the merits of the oral argument. Here's U.S. Deputy Solicitor General Malcolm Stewart, who argued for the government.
The equivalent of the profane past participle form of a well-known word of profanity, and perhaps the paradigmatic word of profanity in our language.
And here's Malcolm Stewart again.
The equivalent of the past participle form of the paradigmatic profane word in our culture.
Here's Justice Samuel Alito.
And the word your client wants to use is number one on the list.
And here's Chief Justice John Roberts.
Vulgar word at the heart of the case.
And among reporters after the argument, Malcolm Stewart's construction was sort of won the prize for most creative.
Absolutely. So what were the government's main arguments last week at the oral argument?
So the government argues that the scandalous marks provision of the Lanham Act is viewpoint neutral. It's not making distinctions based on viewpoint. Of course, there is content that is regulating content, but the government does not believe that it's doing so on a viewpoint basis. But the government did concede that after Mattel, it would seek to narrow the enforcement of that provision going forward, focusing on terms that are shocking or offensive based on the mode of expression rather than the ideas that they convey. And that's a point Mr. Stewart made.
Justice Kagan was a little bit troubled by the idea that the Supreme Court should uphold a law because the federal government was interpreting it narrowly. Here's Justice Elena Kagan.
Mr. Stewart, if you agree with that, I mean, what are we supposed to be doing here? Are we supposed to be looking at the statutory words? Are we supposed to be looking at the fuller standard that the Federal Circuit gave to explain those words? Or are we supposed to be looking just at your commitments as to what you're doing going forward? I mean, if you take the statutory words, they're very broad. They do include things that are offensive because of the ideas they express. So why isn't that just the end of the matter? And if Congress wants to pass a statute that's narrower, that's focused on vulgarity or profanity, then Congress can do that.
Some of the justices, like Justice Alito, asked about exactly what Congress was trying to do when it passed the law.
What is the standard that you're looking to at bottom? And this is framed by Justice Ginsburg's question. What is Congress's interest? Does it have an independent interest in not having the federal government associated with certain words? Or is it just an interest in following whatever the population thinks is offensive or scandalous or immoral at a particular point in time?
Justice Brett Kavanaugh voiced another concern that was on the justice's mind.
How do you deal with the problem of erratic or inconsistent enforcement, which seems inevitable with a test of the kind you're articulating?
Justice Neil Gorsuch picked up on this question, too. He was asking how regular people are supposed to know what the PTA will or won't regard as immoral or scandalous.
Justice Ginsburg's point takes us back to Justice Kavanaugh's, I think, which is you look at the 7 words at the end of the red brief, and there are shocking numbers of ones granted and ones refused that do look remarkably similar. And how is a reasonable citizen supposed to know? What notice do they have about how the government's going to treat their mark?
And you heard Justice Gorsuch there refer to the 7 words at the end of the red brief. That's the respondent's brief, and that 7 words.
Respondent is Eric Brunetti.
The respondent is Eric Brunetti. The 7 words refers to George Carlin's, but just in case you're looking for that, it is available. It's not online as part of the red brief. You kind of have to go to the docket of the case and look for something marked other. And it's probably the dirtiest other thing that I've ever come across at the Supreme Court, because as I wrote about it in SCOTUS blog, it's really parental guidance suggested. It's a list of all the things, not all, but I mean a lot of examples of things that the PTO has either approved for registration or not approved, and obviously it shows some inconsistencies and. You have to be sitting down when you look at that appendix.
I'm trying to imagine Justice Ginsburg reading that.
Well, I think Justice Ginsburg in this case, in this argument, she Slate referred to her as one of the hip kids because she suggested that 20-year-olds might be much more willing to accept the word at issue in this case than the population as a whole. And seemed in tune with that.
This is a woman who has grandchildren, I guess. Justice Gorsuch also responded to Malcolm Stewart's argument that if it had the letters PHUC, and again, you can figure out what that would sound like if you said them all together, the Patent and Trademark Office would look at the context to decide whether to register the trademark. Here's Justice Gorsuch.
I don't want to go through the examples. I really don't want to do that. But I could come up with several that are granted, that have phonetics along the lines you described, and a couple that have been denied. And what's the rational line? How is a person who wants to get a mark supposed to tell what the PTO is going to do? Is it a flip of the coin?
So what were Brunetti's main arguments last week?
So his lawyer argues that the scandalous clause should be facially invalid. The government is regulating offensiveness here and really is making determinations based on the message and the viewpoint of the message. And he argues there's no, quote, mode of expression, unquote, exception to viewpoint discrimination doctrine. And those are a few of his arguments.
Justice Breyer, his wife is a psychologist, had an interesting response to the suggestion that there's no way to generalize what is or is not immoral. Here's Justice Stephen Breyer.
There are books and scientists' reports and so forth. I don't know how. I haven't seen them contested. That say take 6 or 7 words. And today, in the past, they might have been religious. But today, they do include the word at issue, and they do include racial slurs of certain words. And they have a different physiological effect on the brain. They're stored in a different place. They make a difference in the conductivity of your skin, which shows emotion. And above all, they are remembered. And therefore, take that set. Now, if it's in a context where it has that effect, for most people, why isn't that a pretty clear distinction from what you're talking about? And why doesn't the government have a right to say, this is a commercial matter, purely commercial. It is totally free to use any word you want right next to this registered trademark. We just don't want to be associated with it.
And Justice Breyer returned to this point several times during the argument, and he was concerned about, I think, whether this would uphold words like that are at issue here, as well as racial slurs, in particular the worst racial slur you could think of, as it was referred to several times. I mean, that would be the N-word. And, even George Carlin, I think, endorses Justice Breyer's view in his Filthy Words monologue, refers to the psychological effect of some of the words on that list, particularly the F word. And so I think Justice Breyer had some interesting arguments. And
it wasn't clear that anybody else was necessarily buying in on the psychological effect, but even if on the one hand the justices weren't crazy about having the government decide whether something is scandalous or immoral, on the other hand they also weren't thrilled about the possibility that if the law is struck down, anything could be trademarked and would have the government's approval in effect. Here's Chief Justice John Roberts.
You say that, this product's not going to be in Walmart, right?
Correct.
But it is going to be on people walking down through the mall. And, for parents who are trying to teach their children not to use those kinds of words, they're going to look at that and say, well, look at that. And then, they're going to see the little trademark thing and say, well, it's a registered trademark. Well, they won't say that, but.
And we were wondering after that if he was referring to a shopping mall or the National Mall. But since the reference to Walmart had been at the outset, I kind of interpreted it as him walking through the shopping mall, which I'm not sure I've ever seen. But he was one of several justices who were just seemed quite skeptical of Brunetti's arguments, and not sure where this is going after this, even after the decision in Mittal versus Tam.
Yeah, has mentioned it at speeches this term that this is a very First Amendment protective court, and that he is one of the justices on the court who's most protective of the First Amendment. But you're right that it really wasn't at all clear where this was going. So totally aside from the merits of the argument, there was a classic Justice Breyer moment. Justice Breyer's known for his long hypotheticals and questions, and so he had this long monologue. Here's Justice Breyer.
Your basic point, and this is where I'm having a harder time, I think we're in a period where swear words, and that's what they are, swear words, where their content is changing so that younger people feel that these racial slurs are just as bad, if not worse. So suppose that you can pick that out. Sometimes it will be used to convey a message. I grant you that. But this is business. And it's not only business. It is business that has a function of identifying the manufacturer. And it is the kind of use that doesn't forbid anybody from using that word except to get registration, and he can put it right next to it. So it's very different than Carlin. It's very different. Now, I want your response to as much of this question as you can give me.
I really felt sorry for the lawyer in this one because I didn't hear a question in there, and I don't think the lawyer did either.
I think that's right, but he just did the best he could, I suppose.
He did the best he could. Well, I guess we'll find out by the end of June.
And the question is, will the opinion be Elizabethan?
Mark Walsh, thanks for joining us.
Thank you, Amy. I was happy to do it.
That's another episode of SCOTUStalk. Thanks for joining us. Thanks to Casetext, our sponsor, and thanks to our production team, Andrew Ham, Edith Roberts, and John Levitan.